Welcome back. This is episode 7 of our Courts and Trials series. Today we're going to look at the trial. This is, again, not used as often as you might expect. When you watch movies, when you watch TV shows, the trial is the center of the drama. This is where the battle occurs. This is where all the plot resolves itself at the trial. But yet that's only about 5% of all criminal cases will ever see a trial. What are trials exactly? We're going to look at sort of the theory behind trials. We're going to look at how trials are prepared, and then we're going to look at how they are actually presented in court. One of my favorite theories of trial was created by law professor Gary Goodpaster in the late 1980s. He wrote this: "The American adversary criminal trial is a regulated storytelling contest between champions of competing interpretive stories that are composed under significant restraints. The parties compose their stories for and present them to an impartial and passive audience which sits as a decision maker by assessing liability on the basis of the stories." Now let's break this apart a little bit so we can understand what Goodpaster is saying. All right, the first thing he says is this competition is regulated. In other words, there are certain procedures, certain rules that must be followed. The stories must be presented in a certain way. The prosecutor and the defense simply cannot get up and just tell their story as they would if this was a book. We're telling the story through a narrative. They have to do it following certain rules and certain procedures. Perhaps most importantly, though, what we're talking about is a storytelling contest. Right? So you can think of this in terms of a football game or a soccer match or any other type of contest between two sides. Right? You're going to do whatever is necessary to win. And here we're simply having a storytelling contest. So the implication is whoever tells the best story is going to be the winner. As a result, you begin looking at who is the better presenter. Right? The better attorney is the one who tells the story best. Finally, they are champions. They are advocates for their particular side. They must stick to that side, right? You can't have a football game where halfway through the starting quarterback for one team decides, you know what, I'm going to switch sides and go to the other side. Instead, you have to support your team. You have to follow through with your team to the very end. Right? And so they are advocating, they're championing these particular sides. They are interpretive. So these stories are interpreting events. The facts are generally not highly disputed. Both sides are going to agree to most every fact that is presented. What's going to change is how they are interpreted. What one person says was an act of self-defense, another person may say, no, that person was the initial aggressor. What one person may say was an intentional shooting, another may say is accidental. These are interpretations of particular facts, and that's where these two sides are going to be different. And finally, they're told under significant restraints. These are the rules of evidence. What are the rules that govern this particular contest? So the evidence has to be relevant. It can't be character evidence. It can't be hearsay. The documents and items presented must be authentic. Right? All of these different things play a role, and there are extensive rules that have to be learned in order to present your story effectively. So now that we have an understanding of what the theory is of our trial system, we need to move on to how is it that we actually tell this story? What are our parts, or what are the elements of a good story? First off is we got to have characters. Right? So when you're getting up and you're giving your opening statement to the jury, one of the first things that you're going to want to do is introduce who your witnesses are. So you may say, Joe Smith is testifying for the prosecution. Joe was victimized in this particular case. Or Joe is the person who was killed in this case, right? Give the jury an idea of who these people are who are being talked about through this case. What's their background? What's their involvement in this case? What do they do in this case? You want the jury to be able to identify with these particular witnesses because those witnesses are going to be telling that story for you. Also important as we tell a story is the plot. Right? Trials are about assigning blame. They're saying, who is at fault for this? Right? Joe is dead. Who is going to be responsible for it? And so there is a built-in plot there of person against person. But within that, you have lots of other potential plots that you can develop and create your story from. You can say this is a societal problem, a problem of class conflict. You can say that this is, simply an accident. Right? All kinds of different stories can be developed using different types of plot lines. Finally, or most importantly, you also need to provide a narrative. Right? So the witnesses are going to provide the key quotes, the dialogue of your story, if you will, but it's up to the attorneys to supply the narrative, and this is done through opening statement and closing argument. You need to describe what happened. You need to do it in a compelling format. You need to make sure you hold the listener's interest. If you start talking in language that they don't understand, they're going to tune out. And so you have to be very aware of your audience as you're crafting this narrative. And of course, one key piece of that is word choice. What words are you going to use? What labels are you going to use for these different pieces? For example, you may have a police officer who gets on the stand to testify and say that the officer approached the vehicle and identified the suspect of the incident. Right? But you want the officer to translate that into everyday English, right? Making sure instead of a vehicle, it's a car. Instead of the defendant, or instead of the suspect, it's the driver, right? Be able to put it into words that the jury is going to connect with and be able to understand. And then finally, we have point of view. Right? Whose eyes are they going to see this from? Do you want them to have sort of an omniscient point of view where they know everything that goes on from the very beginning? Or do you want it to unfold gradually? Do you want each witness to sort of provide a piece and provide their own perspective, and then you wait for the end to tie everything together and sort of allow some of that drama and suspense to build? Right? So point of view is very important as well. What goes along with these stories, though, is what I would call theme and theory. One time I was talking to a prosecutor who had lost a case, and I asked the question, I said, what was the defense theme in that case? And the prosecutor was able to say, well, this is what it was. And I said, well, what was your theme? And the prosecutor could not give me an answer. And I said, that's why you lost. A theme and a theory is central to the entire case. It's what the whole case revolves around. If you don't have a compelling theme and a compelling theory, you're not going to win the storytelling contest. So what do we mean by theme and theory? A theme is basically a question that answers what the case is about. And the way I would tell prosecutors and defense attorneys when they're creating themes is, if you were asked by somebody, what is your case about? What's a couple word answer or a couple sentence answer that you can provide? One very easy one for prosecutors who deal with drug cases is this. Rule number 1 of drug dealing. What's rule number 1 of drug dealing? Don't get caught. Right? That's a theme. Rule number 1 of drug dealing. Once you know what that rule is, you can build everything around that and explain how the defendant ended up violating that particular rule. That theme also has a very particular benefit to it because it connects to the theory of the case. And the theory of the case is simply the legal reason why you win. And you want to be able to say the theory of the case connects in some way to one or more of the elements that are in dispute in the case. So when we're talking about a drug possession case, the elements are simply this. The defendant was in possession of a controlled substance. The defendant knew that substance was a controlled substance and knew that the defendant had it. And so oftentimes when the police investigate a drug case, the defendant's going to try and get rid of the drugs. And so rule number 1 of drug dealing ties this in very well. Not only does it create something very easy for the jury to understand, but it explains why this person did this unusual conduct, and it explains that they were in fact in possession of the drugs. Rule number 1 of drug dealing, don't get caught. They got caught. How did they get caught? They threw away the drugs in front of the police officer, right? It ties the whole case together. If you can connect your theme and your theory, you're going to have a very convincing narrative that you can present to the jury. And that brings us to the question of how is it that we present this theme and theory? How do we present this story to a jury? The 3 most important words of trial work are preparation, preparation, and preparation. If you recall, Jerry Buting from the Stephen Avery case said that he spent 10 hours preparing for every 1 hour in court. That's a lot of time, right? If you're in court for 2 days, and let's say you're in court for 10 hours, right? That's 100 hours of preparation time that goes into it. And so if you divide that out between even a 50-hour work week, that's two full weeks you're spending preparing for basically 2 days in court. So how is it that we prepare this case? Well, what we do is we actually work backwards. So we start with the very end of the case. We look at the verdict director, we look at the instructions that the jury is going to get, and that's where we start. Why do we start there? Well, we start there because that's the elements. That's what it is the prosecutor must prove to the jury beyond a reasonable doubt. And both the prosecution and the defense are going to start there because the defense must show or must convince the jury that there is reasonable doubt. The prosecution must convince them there is no reasonable doubt. And so they're going to focus on those particular elements, because those elements then become the framework for your closing argument. Your closing argument answers that question of why do I win? It encompasses the theme and the theory. It is your last chance to provide this narrative of how all of the facts that the jury has heard show the defendant is either guilty or not guilty. In order to do that, you have to know what evidence you need. And so if you start listing out in your closing argument all of the facts that you need to prove your case, then you know what facts you need to provide and need to present during the trial itself. And that's where we start going into the case in chief. You know, if you need to prove the defendant had drugs on a given day, that the substance was actually some sort of controlled substance. You're going to need to have the chemist come in and testify that they tested the drugs and the drugs were in fact marijuana or heroin or cocaine or whatever the drug might be. And so you've got to make sure you ask the right questions and you begin thinking about the rules of evidence. What do I need to qualify this witness to be able to give the opinion that these are in fact drugs? What's the process that they used? We need to go through all of that information when we're asking questions. And so that allows us to take our closing argument and then work back to our direct examination. And of course, the defense is doing the same thing with cross-examination. They may want to challenge the expert's qualifications. They may want to challenge the process that was used. They may want to challenge the ultimate conclusion in some way. These then become your questions for cross-examination. And again, if the defense is presenting evidence, the prosecutors are going to be doing the same thing from their side. Right? When we get to direct exam, we want to be thinking about how the witness tells the story. You want to ask questions in a very chronological fashion. You're going to introduce the person, right? The jurors don't know who this person is. Is the jury going to understand this person or like this person if they don't know anything about the person? And so you want to introduce them by name, perhaps where they live, what their job is, why they happen to be there when this particular crime occurred, or if it's the victim, what actually happened to them. This is your opportunity to have the victim explain the conduct. In addition, the way the questions are asked are very important. These are open-ended questions. What is your name? Where do you work? Do you remember where you were on July 3rd, 2015? Why did you happen to go into the park that day? Right? All of those questions allows the witness to answer the question and provide the narrative. The witness becomes the star of the show. That changes when we get to cross-examination. When we get to cross-examination, we want to confront the witness. The attorney becomes the star of the show. The attorney is the one who is basically making statements and getting the witness to agree or disagree. It's much more confrontational. You were out at 10 o'clock at night, weren't you? It was dark then, wasn't it? The sun had set long ago, didn't it? There were no streetlights in the area, were there? You were walking alone, weren't you? Right? Those types of questions are much more cross-examination questions. Finally, once you know all the evidence that you have, then you start preparing opening statements. And now you start laying out. This is your chance to lay out your theme and theory. You give that opening narrative. You place the context for the story that you're going to tell through the evidence. And then finally, you think about what your issues are in the case, and you begin looking at jury selection, because you want jurors who are going to identify with that particular story. And as you see, this process, we begin working backwards. And all of this takes a great deal of time, a great deal of practice, and a great deal of experience. We can't just throw you in and expect you to be able to do all of this. That's why the best litigators are ones who have done multiple trials. And again, as you see, it's very prosecution and defense oriented. The judge has done very little in this process. Once we've presented this case, we turn it over to the jury for a decision, and that, of course, will be the topic of episode 8.